Hello guys, welcome back to our channel Legal Nexus. In today's video, we'll explore one of the oldest and most important source of law, custom. Before there were legislature and written statutes, custom formed the foundation of legal systems across the world. But what exactly is legal custom? How does it become binding and why it is still relevant today? Stay tuned as we break down the meaning, types, and importance of custom as source of law in simple and clear way. Customs are the earliest source of law and form the basis of English common law system. Definition of custom. John Salmon defined custom is the embodiment of those principles which have commented themselves to the national conscience as principles of justice and public utility. In C.K. Allen's view, legal and social phenomena growing up by forces inherent in society, forces partly of reason and necessity and partly of suggestion and limitation. J.L. Austin, custom is the rule of conduct with the governed observed spontaneous and not in pursuance of laws settled by political superior. Essentials of valid custom can be classified into six categories: antiquity, continuous, exercised as a matter of right, reasonableness, morality, and status with regard. All customs cannot be accepted as source of law, nor can all custom be categorized and enforced by the courts. The jurists and courts have laid down some essential tests for customs to be recognized as valid source of law. These tests are summarized as follows. Antiquity. In order to be legally valid, customs should have been in existence for a long time, even beyond human memory. In England, the year 1189, the region of Richard I, King of England, has been fixed the determination of the valid customs. However, in India, there is no such time limit for deciding the antiquity of the customs. The only condition is that those should have been in practice since time immemorial. Continuous. A custom to be valid should have been in continuous practice. It must have been enjoyed without any kind of interruption. Long intervals and disrupt practice of custom raise doubts about the validity of the same. Exercised as a matter of right, custom must be enjoyed openly and with the knowledge of community. It should not have been practiced secretly. A custom must be proved to be a matter of right. A mere doubtful exercise of a right is not sufficient to be claimed as a valid custom. Reasonableness. A custom must conform to the norms of justice and public utility. A custom to be valid should be based on rationality and reason. If a custom is likely to be cause more inconvenience and mischief than convenience, such a custom will not be valid. Morality. A custom which is immoral or opposed to public policy cannot be valid custom. Courts have declared many customs as invalid as they were practiced for immoral purpose or were opposed to the public policy. Bombay High Court, in the case of Madurai Naikon versus Yesu Nakin, held that the custom of adopting a girl for immoral purpose is illegal. Status with regard to in any modern state when a new legislation is enacted, it is generally preferred to be custom. Therefore, it is imperative that a custom must not be opposed or contrary to legislation. Many customs have been abrogated by laws enacted by the legislative body in India. For instance, the custom practice of child marriage has been declared as an offence. Similarly, adopting laws have been changed by the legislation in India. Importance of custom as source of law in India. Custom was the most important source of law in ancient India. Even the British initially adopted the policy of non-intervention in personal matter of Hindus and Muslims. After independence and the enactment of constitution, the Indian Parliament took many steps and abrogated many old customary practice by some progressive legislation. Hindu personal law were codified and the Hindu Marriage Act 1955 and Hindu Adoption Act 1955 were adopted. The Constitution of India provided a positive environment for these social changes. After independence, the importance of custom has definitely diminished as a source of law and judicial precedent, and legislation has gained a more significant place. A large part of Indian law, especially personal laws, however, are still governed by the customs. Personal laws codified under customs. Hindu personal laws, Hindu Marriage Act 1955, Hindu Succession Act 1956, Hindu Minority and Guardianship Act 1956, and Hindu Adoption and Maintenance Act 1956. Kinds of custom. Custom can be broadly classified into two classes: custom without sanction and custom with sanction. Custom without sanction. These kinds of custom are non-obligatory in nature and are followed because of public opinion. Custom with sanction. These customs are binding in nature and are enforced by the state. These customs may be further classified into two categories: legal custom and conventional custom. Legal custom means a custom whose authority is absolute. It is possesses the force of law. It is recognized and enforced by the courts. Legal custom may be further classified into the following two types: general custom and local custom. General custom means customs prevail throughout the territory of the state. Local custom are applicable to a part of the state or a particular region of the country. Conventional custom. Conventional custom are binding on the parties to an agreement. Who two or more persons enter into an agreement relating to a trade, it is presumed in law that they are making the contract in accordance with established convention or usage of the trade. For instance, an agreement between landlord and tenant regarding the payment of the rent will be governed by convention prevailing in this regard. In Suraj Mani Stalla Kujal versus Durga Charan Hansian, the Supreme Court held that for custom to have the color of a rule of law, it is necessary for the party claiming it to plead and thereafter prove that such custom is ancient, certain, and reasonable. In an Adityan versus Travancore Devasam Board, the Supreme Court held that a custom or usage, even if proved to have existed in pre-constitutional period, cannot be accepted as source of law if such custom violates human rights, human dignity, concept of social equity, and the specific mandate of the constitutional and law made by Parliament. So we have seen that customs are not just old practice but the very root from which modern law has grown. They reflect the tradition, belief, and values of society, and when accepted by courts, they gain the force of law, while today's statutes and judicial decision dominate. Customs still play a vital role in shaping legal principles and filing gap where no written law exists. That's all for this video. If you found this video helpful, please don't forget to like, share and subscribe for more legal insights.